Hello everyone and good afternoon. Welcome to the latest Work Foundation event, which today is providing a more detailed briefing on recent research that we've published regarding the potential impact of the government's Employment Rights Bill. My name is Ben Harrison and I'm the director here at the Work Foundation, a research and policy think tank, which is part of Lancaster University. We are committed to supporting everyone to access well-paid, secure employment, and our current work programme is particularly focused on job insecurity for those who face structural disadvantage within the labour market, and as well as that, the interrelationship between health and work. I guess as we gathered here this afternoon, the big focus, politically at least, is on the forthcoming budget. But it's worth remembering that a flagship piece of the government's manifesto and legislative agenda will soon become law, as we expect the Employment Rights Bill to shortly gain royal assent. The bill itself is the product of many years of policy development from the Labour Party, which seeks to substantially reduce the level of insecure work in the UK by increasing access to key employment rights and protections. A few weeks ago, we published new analysis that sought to add to the evidence base regarding the potential impact that this new legislation could have. Now, as anyone who's engaged in that kind of work will know, that's not an easy task, and there are a whole host of externalities, variables, and potentially unforeseen consequences that will ultimately impact on the levels of insecure work that we see across the UK once the Employment Rights Bill is implemented. And some of those fell outside of the scope of the work that we were undertaking. But what I think the research does highlight is the potential scale of the impact that the bill could have, but equally the importance of specific decisions in secondary legislation, in codes of practice and consultations are going to have on how many people ultimately benefit. I suppose in short, the story does not end upon the bill gaining royal assent. In many ways, it's only just beginning. To help dig into the new analysis further and talk about all of the implications around it, I'm delighted that we're going to be hearing from a fantastic panel of contributors today. Rebecca Florison, Principal Analyst here at the Work Foundation, Lord John Hendy, KC, an employment barrister and Chair of the Institute of Employment Rights, and Kate Nightingale, Director of Communications at the Young Women's Trust. To get things going, I'm going to invite Rebecca to provide a brief summary of the research that she's been leading on, which will hopefully set the scene for the wider discussion today. I'll then bring in initial contributions from our other panelists before opening up the conversation and inviting questions from everyone watching online via the Q&A tab. Rebecca, I'll hand over to you now.
Good afternoon, everyone. I'm just looking to do these little technical bits. I can't quite. Trying to start the slideshow here. I hope that is working. There we go. Well, good afternoon, everybody. I'm just going to switch this. There we go. So when we're talking about insecure work, it's worth first getting onto the same page about what insecurity means. Because a lot of the times when we hear people talk about insecurity or precarity in the labour market, people tend to focus on just one specific issue. So, for example, they focus on just 0-hour contracts. But at the Work Foundation, we know that people can be subject to insecurity in many different ways, which is why we've developed a holistic framework for looking at and measuring insecurity in the labour market. So we look at insecurity in the labour market through the lens of 3 different ways in which people can experience insecurity. The first of which is contractual insecurity. So this means situations in which people are not guaranteed future hours or future work. Then we've got financial insecurity, which is where people have unpredictable pay or their pay is simply too low to get by. And finally, we've got a lack of access to worker rights and protections. So we have mapped indicators for insecurity across all of these 3 dimensions, and we've brought them together into our UK Insecure Work Index. And that is also the measurement that we use to estimate the impact, the potential impact that the Employment Rights Bill will have on levels of insecurity in the UK. Now, it's really important to note that none of these forms of work you see listed here indicate bad work per se. It is more that for a substantial proportion of people, multiple forms of insecurity can come together. And if there are any negative impacts of insecurity, we expect those to be concentrated among that group of people. And we certainly know that there can be negative impacts of insecurity. So, for example, we know that people in insecure work are more likely to experience depression and anxiety. We also know that there can be impacts on people's career prospects. So people who are in insecure work find it harder to obtain secure work in the future. And there can also be impacts on the wider labour market and the economy. Now, in 2023, about 1 in 5 workers, 21.4% of workers, experienced severely insecure work. Severely insecure work means that people were in involuntary part-time work or involuntary temporary work, or that they experienced multiple forms of insecurity coming together. So that concerned about 6.8 million people in 2023. Now, those effects are unequally felt. So it's specific groups of people who are more likely to experience other forms of labour market disadvantage, who are also more likely to experience severely insecure work. So that tends to be women. Women are nearly twice as likely than men to experience severely insecure work. It's also young workers, disabled workers, and people from specific ethnic minority backgrounds. Now, the Employment Rights Bill really represents a landmark opportunity to address the prevalence of insecure work. And for this analysis, we are looking specifically at 2 measures within that bill that we're able to measure the impact of using our index. So one of those measures is the new day one rights. So the government is looking to shift the qualifying period to claim unfair dismissal from the current 2 years to a day one right, day one on the job. In this analysis, however, we also consider that you only really obtain full rights and benefits from being an employee once you've passed your probation. Statutory probation is something that is still being decided on, but we have considered about 6 months to obtain full rights and protections. Then we're looking at 0-hour contracts. Government is aiming to introduce the right for workers to be offered a contract that reflects the usual number of hours worked based on a reference period. The length of that reference period is still subject to consultation, but is likely to be around 12 weeks. So what our analysis here is trying to do is estimate how levels of severely insecure work would have changed had these 2 rules come in 2023. And for that, we assume that in this scenario, certain conditions have remained the same. So for example, employment levels would have remained the same as per what the economic analysis from other organizations is showing us is likely to happen. So using this, we've estimated that if these rules, if this legislative framework had been in place in 2023, the number of people in severely insecure work would have reduced by 1.2 million. So that is quite substantial. That is a 3.7 percentage point reduction. The number of people in moderately insecure work would have fallen by about 2.9 million. And I think the particularly good news story here is that the number of people in secure employment would have increased by 3.8 million people if these rules would have been in place in 2023. Another part of that good news story is that it seems to disproportionately affect, in a good way, the people that were most affected by insecurity. So particularly young workers. Among that cohort, severely insecure work reduced by 8.3 percentage points. So that is significantly higher than the 3.7 percentage points that we're seeing overall. Similar for Black and Asian workers specifically, slightly bigger than average reductions. We've also looked at the sectors, some of the sectors in which insecure work tends to be more prevalent. So severely insecure work in retail would have reduced by about 6.4 percentage point by our estimates. But social care particularly is a really interesting story. There, severely insecure work currently, or at least in 2023, affected about 1 in 3 workers. And by our estimates, that would have reduced to 1 in 5 workers under those new rules. Now, it's really important to note that there are still really critical choices that need to be made. So around unfair dismissal and the day one rights, it really matters how long that qualifying period will actually end up being. So we have modeled here what the different qualifying periods would mean for levels of security in the country. So on the left-hand side, you see among the current scenario where people need to wait 2 years to fully qualify, 6.8 million people are in severely insecure work. That would reduce by 700,000 people if the qualifying period became 12 months. It would fall by 1.2 million people if the qualifying period became 6 months. And then there is a smaller difference between 6 months and 3 months than there is between the six months and the 12 months. So the actual length of this period is still to be determined, to be finalized, but the time frame that is eventually selected is going to have a substantial impact on job security in the UK labour market. Now, for 0-hour contracts, the reference period for this remains subject to consultation, and it's also going to depend on the outcome of this bit of ping pong between the House of Lords and the House of Commons. Previously, the House of Lords wanted to make this right to be offered guaranteed hours into a right for workers to request guaranteed hours. That would have meant a significant weakening, and it's a good thing that the Commons have rejected that, because as we know from our wider research, a right to request is not a right to have, and lots of people would have stood to miss out. Now, the Lords have come back last week and have suggested new wording for this, which is that after the initial reference period, workers should be notified of their right to be offered guaranteed hours, and workers can then opt in or opt out. I expect we'll see a lot more about this. This is due to be discussed again in the Commons tomorrow. So the findings of this piece of research really highlight that the Employment Rights Bill has the potential to substantially improve access to secure work in the UK. But what it also highlights is that it needs a strong legislative design and robust enforcement to fully realise the benefits. And in light of this, we recommend that government ensures that the potential of the Employment Rights Bill is maximised, and particularly that the core purpose of those reforms are safeguarded, both in primary and secondary legislation, so that they are not weakened. We also consider that there's going to be a lot of new rules, a lot of detail for both workers and employers to familiarise themselves with. And it's really important that governments support, particularly smaller organisations, with that process so that there is a smooth transition. A really key element to this as well is appropriate enforcement. In the current scenario already, under fewer rights, it is sometimes difficult for workers to find redress. So appropriate resourcing of enforcement is really, really key. Also, it's important that the impact of this bill is monitored. And for that, we have suggested that government set up a secure work task force that is tasked with ensuring that the bill is implemented and that its impact is appropriately monitored. Now, as to next steps for this bill, this is based on the government's own timeline, their roadmap. It seems like some of the timelines are slipping. Currently, the bill is still going back and forth between the Lords and the Commons. There's also quite a bit of time needed. About 4 or 5 consultations have come out already. They were going to do that in a staggered way, but bringing out a host of new ones as well, analysing them, responding to them, everything takes a lot of time. Furthermore, it can be hard to launch consultations on details that are still being worked out between the Commons and the Lords. Ultimately, this bill could certainly result in a substantial reduction of insecure work, but what it also highlights for me is that it doesn't reduce insecurity to zero. And so a lot more remains to be done. Thank you.
Brilliant. Thank you so much, Rebecca. That's really very helpful. I'm now going to bring in Lord John Hendy, if I can, to offer his reflections both on the research that Rebecca has just been describing. But of course, Lord Hendy, you've been actively engaged in some of those debates that Rebecca was referencing. So it would be great to get your more general reflections on the Employment Rights Bill and its forthcoming implementation as a whole too.
Thank you, Ben. And thank you, Rebecca, for that excellent presentation. I've got 3 points to make, really. After saying that the piece of research that Rebecca's done is very impressive indeed, I hope that what she has calculated comes to pass, but I am a bit dubious that it will. And there are 3 reasons that are in my mind. The first is that the bill failed to confront the elephant in the room, which is the differing legal status or categorizations of workers in UK employment law. So you've got the employee with a contract of employment entitled, at least on paper, to all the employment rights. Then you've got what the lawyers call the Limb B worker, which is a sort of intermediate category, not an employee, and only entitled to some of the employment rights. Then you've got the self-employed, who are not an employee or a Limb B worker, but and have very few employment rights indeed. And then employers have created other categories as well. Some people can't get work unless they form a one-person company. So John Hendy is employed by John Hendy Limited. John Hendy Limited is contracted by the employer to supply the services of John Hendy, and I have employment rights, but only against my own one-person company. And there are other devices as well, agency workers and so on. And the original proposal in the Labour Party document of 2021, a New Deal for Working People, was that all these categories, apart from people who are genuinely self-employed in business on their own account, all these categories should be brought as one. And the problem now is that the government has not confronted that problem. They say they'll consult about it in due course. We don't know when that is. But with the new rights, particularly day one rights, employers have now got the incentive to recategorize their workers so that they have less rights than the existing workforce. So, for example, if you want to claim unfair dismissal, you have to be an employee. If your employer then changes your status to being a Limb B worker or a self-employed worker, you haven't got that right. And I can see that employers will succumb to the incentive to recategorize workers. We don't know what the extent of that will be, but it may eat away into the diminution of insecurity that Rebecca's spoken about. The second point is one that Rebecca did make very forcefully, and that apparatus, this machinery of the Employment Rights Bill, needs strong enforcement. And that enforcement is left to individual workers. It's true that the government's going to set up a Fair Work Agency, which can intervene to secure workers' rights in an employment tribunal. But given that there are some 50,000 cases brought a year currently, and that figure is likely to increase, most cases are going to be brought by individual workers. Now, the disincentive of doing so in terms of resources, lack of legal skills or access to lawyers, to money, to time, to the risk to your chances of getting other employment are so great that many workers are not going to be able to enforce these rights. And rights without remedies are useless. So I think that there will be a lot of workers who look at the bill and think, wow, that sounds good, load of new rights for us. But in reality, a lot of workers are never going to bother to enforce their rights, which will increase insecurity at work. And the third point and last point I wanted to make was that The government was invited to develop mechanisms for collective bargaining, particularly sector-wide collective bargaining, which would have fixed terms and conditions by negotiation between unions and employers. That's the situation that we had for most of the 20th century, but it's been demolished in the last 40 to 50 years. And the consequence is that 3/4 of our workforce have got no say whatsoever over the fixing of their pay, hours, terms, and conditions. They seek a job and they're told these are the terms, take it or leave it. And that adds to insecurity. It gives the employers an absolute upper hand in importing insecurity into work. Thanks.
Thank you so much, John. Some really very helpful challenges there. And we're going to revisit each of those as we go through the conversation this afternoon, I'm sure. Before we do that, Kate, I want to bring you in from the Young Women's Trust for your reflections, both on the research, but also your hopes for the Employment Rights Bill as a whole.
Thank you, Ben. Yeah, I'm from Young Women's Trust, so we represent young women aged 18 to 30 on low and no pay. So particularly groups of people who are really set to benefit from this bill quite disproportionately. So it was great that this research really pulled out that certain groups of workers are overrepresented in insecure work and therefore sort of stand to gain more from the bill. Young workers, women, Black and racially minoritized workers in particular. So we know that the Employment Rights Bill as it stands will be hugely welcomed by them and can't come soon enough. I think thinking about the real life impact on some of those workers of having increased job security, so being able to budget from week to week, month to month, being able to plan their lives, plan things like childcare, not losing out on the costs of childcare that you've had to pay up front and then your shift gets cancelled at the last minute. Having the security to be able to challenge unsafe, toxic, unfair workplace environments. At the moment, we know that a lot of young women workers in particular are putting up with all sorts of unfair treatment, discrimination, sexual harassment in the workplace because they're on an insecure contract and they worry about losing their hours altogether if they challenge it. And also we know that young women, particularly even more than young men, are very likely to get trapped in insecure work. So having that increased job security is likely to have a real sort of knock-on impact on what they're able to do in the rest of their working lives as well. So it's really clear that this bill has to work for young women. We are also particularly concerned about the enforcement of the bill, and that's really where it sort of lives or dies. We know at the moment that young women are a group of people who are least likely to be aware of the rights they have, and because of that huge power imbalance in the workplace, particularly combined with insecurity, are least able to challenge it when they're not getting their rights. So the bill needs to be accompanied by a really targeted awareness campaigns to make sure workers know what they're entitled to, and then really strong enforcement. As Lord Hendy has said, it doesn't mean anything if those rights are not real in practice. So how the Fair Work Agency is resourced, how it targets its activity, particularly on those groups of more marginalised workers or workers in industries like retail and social care, where we know poor practice is particularly bad. How it works with other agencies that are involved in enforcing other rights, particularly inequalities, so the Equality and Human Rights Commission, how easy those systems are to use as a young, potentially marginalised worker, will all have a real impact on the ability of this bill to be as transformative as it really promises to be.
Brilliant. Thank you, Kate. I'll invite Rebecca and John to put your cameras back on now as well, if that's okay. And we'll move into the open part of the conversation. We've had a couple of questions in already from participants. And just to remind everybody, if you'd like to ask a question or make a contribution, if you can use the Q&A tab, that would be great. And I'll come to some of those in a moment. But Rebecca, I'll come to you first, if that's okay, because I thought the point Lord Hendy made in his reflections around the potential unintended consequence of some of these reforms in the absence of worker status reform could be to essentially move workers into even more precarious forms of work than they were in the first place. And I know as part of the research, you had a little bit of a look at some of the kind of gig economy models in the retail sector that we might already be seeing emerge ahead of the finalisation of the Employment Rights Bill.
Absolutely. I think with any of these kind of reforms, there is always the risk that it opens up spaces for loopholes, or that particular employers will be trying to dodge those new rules through a myriad of ways. So we looked at the retail sector, and we found that some companies were making use of gig work platforms to give people just a few hours of work here and there. So pay was incredibly unpredictable, and some people found it difficult as well to get their pay on time. Finding redress if there's issues as well can be very, very difficult. We also looked at a case study of the Netherlands, where there's also talk of more of a wholesale ban on 0-hour contracts, and it also seemed to precipitate a bit of a shift towards more self-employment, people being sort of forced into self-employment, but still also in very pernicious kind of insecure circumstances. So certainly something to keep an eye on.
Thanks, Rebecca. And John, just to come back to you on that, because we've had a question from Daniel Carter in our audience, where even in the more perhaps optimistic scenario that our analysis sets out, we've still got quite a large number of people who would be in the sort of severe end or moderate end of insecurity by our index. And you've alluded to a sort of a number of pieces of this puzzle which are still missing, in a sense, I suppose. What would you see as the sort of legislative imperative through the rest of this Parliament to build on whatever progress the Employment Rights Bill makes? And are we realistically going to see that, do you think?
Well, time is running out for this government. They've only got a 5-year term. The roadmap for the Employment Rights Bill runs into 2027 already. But if they are genuinely going to deal with the legal status of workers, that means that there has to be a second piece of legislation to deal with it. Can't be dealt with by regulations or changes of policy. It needs legislation. And if there is to be a second bill, as a number of trade unions are currently asking for, including the Campaign for Trade Union Freedom and so on, if there is to be a second bill, then there are some other things that need dealing with, which I won't weary the audience with now, but one of them is a mechanism for extending collective bargaining, particularly across sectors. And some of these sectors are absolutely desperate for standardized terms and conditions on a national basis: hospitality, agriculture, parcel and food delivery, and so on, where we know, everybody knows, that millions of workers, not just a few 100,000, but millions of workers are competing with each other to work on the lowest conceivable income and terms and conditions, because employers are exploiting the differences in legal status and the absence of collective bargaining. Collective bargaining, of course, has the other advantage that it, from the employer's perspective, that it prevents the undercutting of good employers by bad employers on labour costs. So that will be my priority.
That's really helpful. Thank you, John. And Kate, to come to you, I mean, you've already reflected on the importance of this bill for young women in particular, but given what Rebecca's reflected on and some of the sort of priorities for the future that Lord Henley's just outlined, are there particular things that you're looking for as government takes this forward, or would have concerns around? You mentioned enforcement being one, but in terms of the sorts of particular designing of and implementation of some of these reforms, are there particular areas that you are concerned about with the choices still to be made?
Yeah, I mean, we're particularly concerned with the 0 hours contract reforms because it is which will impact so many young women on insecure work. And so, you know, the ping pong going through at the moment, like, we're very concerned about any watering down of that. Even the suggestion now that employers will need to write for, will just have to write to their employees to say that they are entitled to a 0 hours contract. That still leaves room, as far as we can see, for a worker to be pressured not to take that up. And we can see that, we know that happens a lot at the moment. There's a sort of, this is what we're legally saying to you, but don't do it. And young women are potentially particularly sort of vulnerable to some of that. So really sort of concerned that goes through as it was written in the original bill, and that we keep an eye on that and any sort of potential loopholes. I think then it is for us about sort of monitoring the real impact on young women, like I was saying, this sort of awareness of the rights, the design of the enforcement system, the kind of gateway that workers go through, that are the things that we would be most concerned about. I think thinking about going further and what we would want in future, some of this is less sort of legislative, but one of the concerns we have is something I alluded to in my opening, was about the likelihood of workers, particularly young workers, becoming trapped in insecure work. And we know from our research that often in those sort of short-term insecure contracts, there's no focus on development, training, progression. Often people take those jobs because they think it might be, a stepping stone, or they just need some income, get this job, and then I'll move on to other things. And that doesn't tend to happen, particularly for young women. So would love to see more of a focus, once we've got that basic security in place, on how we can sort of give development, training, learning, progression opportunities to people in those jobs, so that they genuinely are a stepping stone and not the trap that they seem to be becoming at the moment. But I think that's, let's get this bill working, I think, first, before we dream of such things.
Quite so. Thank you, Kate. And certainly previous Work Foundation analysis has found that, far from being the kind of stepping stone into more secure employment, as things stand, actually for a great number of people, it is a trap in secure work, and people have struggled to kind of progress on from it. Rebecca, I did want to just come to you on 0 hours contracts in particular, given Kate reflected on that as a priority. And anyone who's watching and listening who has looked at the research might be a bit surprised that we don't calculate the impact of 0 hour contract reform in itself as having so much of a substantial difference on moving people out of severely insecure work. But it's still really important, isn't it? And it would be good just to give you the chance to sort of reflect on why that bit of the reform still matter so much.
Absolutely. So a bit of that story for us is technical because of the way that our insecure work index works. We don't measure 0 hour contracts directly because that's not consistent. It's not a consistent measure over time. So we look particularly at unpredictable hours and pay when you're on a 0 hours contract. So 0 hour people, the number of people on 0 hour contract is about 1 million. The number of people who have that unpredictable pay is a subset of that. So although that's a substantial group of people, when you then look at the percentages, the impact might seem a little bit small. But actually, from the work that we've done, from the interviews and the focus groups that we've done with people on 0 hour contracts, we know that a lot of them would prefer much more guaranteed hours. We know that a lot of them find that insecurity really pernicious. It is literally costing them. They are unable to plan their lives. They pay a lot more for regular services, like often last-minute transportation, last-minute childcare, things like that. So when we look at it in that way, although it might concern sort of a smaller subset of the workforce, the actual impact of that security for those people is going to be absolutely really, really important.
That's really helpful. Thank you, Rebecca. John, I'd like to come back to you if that's okay, because you mentioned as one of your sort of key points at the outset, the enforceability of rights, and it's something which Kate and Rebecca have both reflected on as well. And we've had a question from Heather Taylor around what does Matthew Taylor, I'm assuming no relation there, and the Fair Work Agency need to prioritise in order to get this picture right. And I suppose it speaks to around the resources required, but I wonder whether there's a broader point here around the sort of infrastructure as a whole that we have around enforcement of rights, because tribunals, of course, I think, as you alluded to, are already under significant pressure. And as you said, it sort of places the emphasis on the worker themselves. So do we have the sort of infrastructure as a whole right to be able to go on to enforce these new rights as they come forward?
Well, there's two issues here, really. The narrower one is whether the Fair Work Agency will have the resources to make a significant impression on the enforcement of workers' rights. one suspects that they will not. If you look at the way that the Health and Safety Executive funding and resources has been slashed over recent years, it's not been restored by the current government. I wonder whether the Fair Work Agency will have the resources even to undertake the most egregious cases, the worst cases which come its way. If it did that, it would still leave the tens of thousands of more modest claims of workers, because it would have to obviously marshal its resources. I just wonder whether a worker who has been cheated out of £500 of her holiday pay is ever going to take a case to a tribunal and wait for 18 months for the case to come up and take her chance on whether she wins or not. That's the narrow issue. The bigger issue for me is that over the last 50 years, we've moved from a situation where the relationship between worker and employer was formally negotiated, or at least for 3/4 of the workforce, to a situation where it's a matter of litigation. And I think the idea of conducting industrial relations by litigation rather than negotiation is a recipe for failure. Well, it's not for the employer's point of view, because it solidifies their advantage, their power over workers. But it's not the route to some form of equalization or balancing of the position of the worker vis-a-vis the employer. I think I may be old-fashioned and quite elderly, but I think we ought to go back to negotiation rather than litigation, even though I'm a lawyer and lawyers are going to do very well out of this.
Just staying with you, John, just very briefly, because we have had a question from Stephen Mercer, who works extensively, he says, with Limb B workers, and is saying that a good number of them like to work flexibly. And I suppose we've touched upon this a little bit in other responses from yourself, Kate, that actually, why not accept the Lord's amendment that each agency worker has the right to request a permanent contract as opposed to a right to have one? Now, there's issues around all of that in terms of power and who has agency with a small a in that negotiation. But I just wanted to get your reflections, given this was something you addressed in your opening remarks, John.
Well, I think Rebecca's really dealt with the question, and Kate indeed, about the distinction between asking for a guaranteed hours contract and being offered a guaranteed hours contract. It simply fails to recognise the imbalance of power between the worker on the one hand and the employer on the other. I mean, can you imagine that in a McDonald's or something, the young, I don't know, let's say 21-year-old worker saying, "Look, I've been doing 50 hours a week for the last 12 weeks. I'd like a contract that reflects that." I mean, the employer's simply going to say, "Well, of course, you're entitled to one, but by the way, until we get this sorted out, there won't be any work for you next week." I mean, it just doesn't recognise the realities of power at the workplace. I'm sorry I said McDonald's. I should have said some theoretical organisation, hypothetical, that doesn't exist. But the other point that you made, I forget what the other point was. What was the first point you mentioned, Ben?
Oh, so just in terms of that sort of right to request, but I suppose I think you've covered it, to be honest, actually, John, in terms of the where the kind of power dynamics within organizations themselves will make that very, very unlikely if the emphasis is on the individual to request.
Yeah, I know. The point was that you said, well, some Limb B workers like being Limb B workers, and of course one accepts that. There's plenty of 0 hours workers that like being 0 hours workers. It's the fact that a majority, and we know it's a majority from surveys, don't want to work like that and are obliged to do it because they've got no economic alternative than to accept work from an employer who insists Limb B status or 0 hours contracts. And by the way, one of the reasons that Limb B workers like being Limb B workers, same as a lot of full self-employed workers like being self-employed, is because it has certain tax and national insurance advantages. But just because you change the legal status of the worker as worker doesn't mean you have to change the status of their tax and national insurance liabilities. I mean, that's there's no inherent necessary connection between the two. And what I'm interested in is a single status for the work relationship. What happens to tax and national insurance is a matter for the Treasury. They can either follow the pattern or make it different.
On that note of the Treasury, there, I did want to just move us on. So we've got around 15 minutes or so for the remainder of the event. And obviously the Chancellor did a sort of fairly extraordinary statement this morning ahead of the budget, where she spoke in terms of achieving both growth and fairness. And a lot of the debate around the Employment Rights Bill, from some parties at least, has been that it will in the end be anti-growth, that it will reduce hiring from employers and it puts too much risk on employers themselves, which will ultimately constrain their ability to grow and have an impact on living standards and all the rest of it as a result. And so I just wondered, Rebecca, given your work on this research, and then Kate, I'll come to you around it as well. Is there a real sort of a sort of division here where you can only have one or the other, or should we actually be thinking about the idea that making work more secure can also drive growth in the future as well?
I would think that driving up the quality of work and the security of work can certainly be an economic boost. I think we shouldn't forget that this is very much a wage-led economy, and so secure and good pay in people's pockets will have economic benefits, I think, particularly in local economies. I also think that driving up that security of work is a really important manifesto promise made by this government. And it actually finds a lot of support as well across the board. There have been opinion polls that have shown that across the voter spectrum, a lot of people would like work to be better and to be more secure. So I think there's only advantages in government basically sticking to that promise, which I think in the end will benefit both workers and the economy as a whole.
And can you say that's really helpful, Rebecca? Can you say just a little bit around what the Department for Business and Trade have found in their evaluation of the potential impact for employers? Because I guess, again, a lot of the heat of this debate has been this idea that it's a disproportionate cost to employers.
Certainly. So the economic analysis by the Department for Business and Trade had shown that they're not expecting to be particular impacts on employment levels. So we're not expecting that the burden on employers will be so high that they'll need to be laying off staff. There will initially be some familiarization costs, which basically means that people working in HR or organizations will have to get familiar with the detail of the new rules coming in place, so that they can meet their obligations. That comes with some small costs attached, but those are definitely not substantial enough to have any particular impacts on the economy or on employment levels.
Brilliant, thanks, Rebecca. And obviously, there's a lot of unknowns around all of that. It's worth bearing that in mind, I think. But Kate, are you worried that these new regulations, as they're rolled out, could see younger women, in particular, given your organisational focus, find that there are fewer jobs available to them? And I suppose if you take it together with other things that are impacting the labour market, such as AI and technology, that we may see this sort of further erosion of entry-level jobs for young people, even if the sort of intention of the legislation itself is a positive one to make work more secure.
Yeah, I mean, actually, on the contrary, some of the research we've done is finding that because of insecurity, unfair treatment, bad treatment at work, toxic workplaces, impact on mental health, and so on, young women are actually dropping out of work, and there's potentially going to be an impact here that means like better, more secure work means more young women can stay in their jobs and do well. So I would say the view we have is that this is this is good for them, will keep them in the workplace, and will therefore be good for the economy if we're not seeing that kind of impact on them. I think, similar to the point Frances O'Grady made in the Lords last week, employers have worried about impact of national minimum wage and gender pay gap reporting, and we of course seen concerns about those things that have then in reality turned out not to be not to have borne out. So I think we also are aware of employers saying this is a good thing. It levels things up. A lot of businesses want to treat their workers well and not be undercut by others for doing so. So I think the view we have at Young Women's Trust is that this is likely to be kind of an economic benefit, not a downside. I think interestingly on AI, there's definitely something we're looking at in terms of what is the impact going to be on those kind of entry-level jobs. One perspective I've heard recently on that is that it's those human kind of jobs, like the caring jobs, the social care, those kind of roles that young women are largely going into, that might actually be safer from AI. So who knows? There's lots of theories on that, and something we're definitely keen to look at into the future, because it's one of the other big forces acting on young women in the labour market.
Brilliant, thank you, Kate. And John, you've been engaged again in some of those Lords debates where this has been an issue raised by peers with other perspectives on this, and it'd be great just to get your sense of how those debates have played out, and the extent to which you feel that there are risks here that we will see unemployment creep up as a result of these changes.
Well, I don't accept the premise of the Conservatives. I mean, there's two short points here. The first is that employers don't employ people to do them a favour to reduce unemployment. They hire people because they've got work that needs to be done in order to turn a profit. And it just seems ridiculous to me that the idea that employers are going to lay off hundreds of thousands of people because the risk of them of workers suing them for unfair dismissal or increased paternity leave or whatever it happens to be. I don't think that's realistic. And the other point is that we've suffered from a low wage economy, stagnant real wages for the last 15 years or so. We are a low wage economy now in Europe. It does us no good at all, particularly a service economy. You want money in people's pockets in order to spend, because that increases the demand for consumption, which provides the market for the goods and services that employers provide. And it's just nonsensical to reduce wages and expect the government, the economy to grow. It just doesn't work like that. What we need is a high wage economy, like they have in Scandinavia, with a high standard of living and people spending money. That's what we want.
That's really helpful. Thank you, John. I'm conscious that throughout the conversation, we've sort of been talking about that sort of subsection of employers who we fear may see this as something to be circumvented or to sort of actively pursue loopholes. And of course, there's a whole rump of employers who won't approach this agenda in that way, and that we know that already are embracing the reforms. And Rebecca, we've had a question from Ruth Webber, which is particularly around sort of the role of peer learning and accountability for employers, or the way in which employers can learn from one another. And I know in previous research you've done around this topic, you have been able to identify, even in sectors which tend to have greater concentrations of insecure work, employers who are leading the way to more progressive practices.
Absolutely. I think definitely some employers can see that it affects their bottom line, and that offering insecure work has maybe some short-term gains, but there's also really long-term impacts in terms of retention and the health of their workers, etc. So often strategically, it can make a lot of sense also for their bottom line to improve that situation. There's a really interesting example of the hospitality sector. So this is one of the sectors that tends to see like a really high prevalence of insecure work. So there is a pub chain, which we shan't name, but they had over 40,000 staff working in the UK and a lot of people on 0-hour contracts. And then in 2016, they decided to offer their 0-hour contract staff an opportunity to either opt in or opt out of that contract. And 99% of that staff opted into guaranteed hours. Which have then been implemented. So that's definitely an example of a really progressive employer who's really listened to their staff in this regard.
And undermines the point that it's simply impossible to do in some of those sectors, notwithstanding each organisation will have their own challenges. Kate, I wonder whether from your perspective at Young Women's Trust, you've sort of come across particular examples of employer practice which are actually much more in line with the sort of direction of travel on the Employment Rights Bill.
I'm actually on 0-hours contracts. I'm struggling to think of an equivalent example. It's absolutely great to hear that case study of an employer doing it willingly and freely and seeing a good impact from it, and that keeping their workers like secure and happy is a good thing to do for business as well. I think we've definitely seen some areas of good practice around other elements of the bill, like employers doing flex really well in sectors that might have been thought of as difficult. So I know Timewise have done a lot of sort of pilots with people like health and social care and with retail workers, where it's typically thought of as being very hard to do flexible working, particularly flexible working for sort of supervisor and manager level jobs, and some really good case studies there to look at of kind of how that can be made to work in some of those sort of frontline jobs. So I'd definitely point to that, but I know of less on the sort of job security and the 0-hours contracts side of things. So I'll be banking that case study for my own use. Thanks, Rebecca.
Excellent, thanks, Kate. We've had a couple of other questions that I think we can get to. One which I maybe just can head off, but please do feel free to chime in, each of you, which was around the reform to statutory sick pay, which is going to be available from day one of absence under the reforms. And the question's around, will it make employers more or less likely to employ people with disabilities or health conditions? And Stephen has come back quite helpfully to remind us that discriminating in that way is already against the law and therefore shouldn't be something that's happening. But I guess what I would also say is I've been involved in the campaign for safe sick pay over the course of the last 12 to 18 months. And the evaluation analysis that colleagues have undertaken as part of that suggests that actually the impact will be minimal in terms of the sort of response from employers, and actually where employers have already implemented more generous statutory sick pay policies, they have not seen a rise in absences from the workplace. Actually, quite the opposite, as people are able to take the time out of work in order to get better, which is obviously very, very important. Another question from Tom Stevens, and Lord Hendy, I'll come to you if that's okay, because it's around sectoral collective bargaining. And Tom would like to understand whether this is going to require additional primary legislation in order to do some of that, or whether it's possible to extend collective bargaining to additional sectors beyond the ones that government has already alluded to, and whether this has been discussed already in the Commons or the Lords.
Yes, it has been discussed. The government have introduced a sort of truncated version of what could be described as sectoral collective bargaining for adult social care and for school support staff, but it's not. Well, we haven't got time to go into it now, but it's not really collective bargaining in any meaningful sense, and the minister can override whatever the parties agree. I introduced, and colleagues in the Commons also introduced, measures to enable the Secretary of State to introduce sectoral collective bargaining in any particular sector that he or she thought appropriate, but the government rejected those mechanisms. So in order to do it by statute or have a legal mechanism for introducing sectoral collective bargaining, it would be necessary to introduce further legislation. As I said earlier, there will have to be a second bill because of the status of workers issue. So that might be the chance to introduce this a mechanism for sectoral collective bargaining. I mean, the law is not enough by itself. You need other things as well. You need a government that's committed to supporting and fostering collective bargaining. You need other mechanisms which, well, I won't weary you all with them, but the critical thing, I think, is to have a legal mechanism like we had in the past with the wages councils and so on, to allow sectoral collective bargaining to get off the ground.
Brilliant. Thank you, John. So just we've got time probably to just tie up a couple of other things that have come through in the Q&A, or one thing in particular, which is the impact that all of this could have on small employers in particular, who may not have the kind of capacity or specialist expertise internally. And Rebecca, I wonder if I might come to you, because I know one of the kind of key recommendations of the research is this idea of supporting employers for a smooth transition, and whether there are particular things you'd sort of point out are going to be important with, I guess, with SMEs in particular in mind.
Yeah, a lot of SMEs don't have the capacity. They have very limited time and resources. A lot of them lack an HR department, so that can make it difficult to then become properly familiar with a lot of new legislation coming through. I think what is really important is that a lot of this is staggered. So it's coming in quite slowly, one thing after another, which gives people quite a bit of time to get familiar. I would also say that in a lot of cases, businesses are actually already doing what is said. It's just about raising the standard for the ones that are not doing it. And government is certainly looking into how they can best support organizations. So of course, ACAS is always a fantastic resource for employers to look at. And there have been pilots done with supporting SMEs in improving sort of their management practices and their familiarity with these sort of things. So I would say they should keep an eye out, and government definitely should support these organizations.
Fantastic. Thank you, Rebecca. So we're going to bring the event to a close shortly because we're up against time. But I just wanted to give each of our contributors the opportunity in around 30 to 45 seconds or so to give us their sense of how optimistic we should be about the potential impact of the Employment Rights Bill, because we've talked about a lot of opportunities and challenges through the course of the conversation, and anything you think should be prioritised to make sure that that impact is maximised. Kate, I'll come to you first.
Thanks. I think I'm cautiously optimistic. If the Fair Work Agency in this crucial kind of phase of being established is set up right, if it's given the powers and the resources that it needs, if it has a real targeted focus on marginalized groups of workers and those industries where kind of poor practice and insecurity is most common, I think that to me is what this rides on. Praying for Matthew Taylor to really take up that mantle, and he's been a real champion of this work. So with him in post, really hopeful that it will get off to a really good start, because I think it's the bill is really key. Hopefully it'll get through ping pong intact, and then it's the Fair Work Agency really establishment that gives it its fighting chance. So yeah.
Brilliant. Thank you, Kate. Lord Henley, I'll come to you next.
Well, there's no doubt that the bill represents a sea change, and it's a positive thing that workers should be supported by legislation after all the attacks in legislation that workers and trade unions have undergone in recent years. But I don't think it's going to be as transformational as some people suggest. And it definitely needs the legislative program needs further attention in the respects that I've already mentioned. We have to sort out the legal status of workers. We have to secure collective bargaining on an industry-wide basis. And we have to move away from the idea that disputes at work are to be resolved by litigation brought by individual workers in employment tribunals. There's got to be something better than that.
Brilliant. Thank you so much. And Rebecca, I'll give you the final word.
I think I'm relatively optimistic. I also see this as such an important opportunity to address insecure work. But certainly I think enforcement is going to be really key to this picture.
Brilliant. Thank you, Rebecca. And thank you to all of our speakers this afternoon. Very, very grateful for your time and your experience and your wisdom. And thanks to everybody who has attended and the Work Foundation team who lead on producing our analysis and on putting sessions like this together. At the Work Foundation, we've got one final online event scheduled for 2025. We have a Work Matters event on the 19th of November, which will be all about the critical budget statement to come the following week from the Chancellor. You can register for that via our website now. And you can also find the full report from today on the Work Foundation website, alongside a host of other research on insecurity in the UK labour market. For now, though, thank you once again. I hope you found the discussion valuable, and I hope you enjoy the rest of your day.